Hello there. My name is Miki Turner. I am Turner ESQ on Twitter. I run a little blog called Soccer ESQ, which is basically a site that covers legal issues in soccer and write for The Athletic as well. And decided that since we're near the end of the year, it would be a good time to have a couple of attorneys that I talk with quite frequently about all of the lawsuits going on in soccer. Professor Stephen Bank, who's out in LA, UCLA, and Neal Morris, who's out in California or in North Carolina, excuse me, covering lower division soccer out there. So say hello, hello guys, and I guess I'll start with you, Stephen, and just say hello and kind of introduce yourself.
Well, thanks for having me, Mickey. So as Mickey said, I'm a professor at the law school at UCLA. I teach international and comparative sports law. I teach a couple seminars on soccer law, which is probably, not just probably, is the only soccer law course in the country, I believe. And written a variety of articles. And in fact, I have one coming out on reforming FIFA, which you'll have to wait and take a look at. But this is more domestic, I guess. Than we're not going to handle the international stuff here. In any event, I'm happy to be here, and I also tweet at Prof Bank.
My name is Neal Morris. My bona fides are far less lofty. I've been an attorney for over 20 years in North Carolina, and I have managed, for the most part, until lately, to keep my peas and carrots separate. My soccer writing began in 2009 as a hobby, covering the local North Carolina second division team that's gradually expanded into the North Carolina Courage and, of course, the leagues that they cover. And as lower division soccer is wont to do, or any division soccer, and frankly in this country is wont to do, it somehow found its way into my day job. And so the attorney job that I have, mainly working for a small firm up until 2014, I mediate and arbitrate now, which is what I've done all across North Carolina for the last 4.5 years. And I still write about soccer. And so those two occupations have converged from time to time, often to my benefit. And so here I am.
Yeah, and I guess apropos of you talking about lower division soccer, I guess as we're going to start off our discussion, because we got some breaking news yesterday that from Paul Tenorio at The Athletic, that Ottawa Fury, USL team, the only team playing in the USL Championship, which is now the second division team in U.S. soccer, they have been denied sanctioning from CONCACAF, and as such do not have a league to play in at the moment. USL actually just, before we started broadcasting, released their conference alignment, which still includes Ottawa Fury, and their schedule, I think, is supposed to go out next week. So that obviously presents a problem because Ottawa was obviously a big part of USL's plans for next year. And as of now, they are not authorized to participate in their season. And so they have a lot of work to do in a short amount of time to try to rectify the situation. This is coming from CONCACAF. This isn't coming from U.S. Soccer. It's not coming from Canadian Soccer Association, CSA. It's coming from CONCACAF. And they are required to get permission from CONCACAF to play in a non-domestic league if there is a domestic league available for them to play in, absent exceptional circumstances. And as this news came out, Neal and Stephen and I were scouring CAS and the internet to try to figure out what the heck was going on. So I guess I'll just throw it out there. Neal, what's your thoughts on where we are right now and how this came about and kind of where we go from here?
Well, a lot of this is sort of reactive. We're kind of trying to piece it together as we go along. This may have been something that folks behind the scenes who was possibly caught everyone else off guard. Obviously, the new Canadian Professional League that was being formed supposedly doesn't have a problem with that. Of course, the head of CONCACAF, who has ties to Canada, clearly does. And I think what caught people off guard isn't that this came to a head. I think a lot of folks wondered about this limbo or this limbo stage that Ottawa was in, wanting to remain in the United Soccer League just as a Canadian league or Canadian professional league was starting up. I think what caught folks off guard is that this came to a head now before the new league has even kicked their first ball, which could be a league, in some ways could be a relevant legal aspect to this, depending on what route this goes. It certainly represents a hardship to Ottawa, given the fact that they've been signing players and re-upping contracts that are connected or under USL contracts, have to be approved by USL and probably can be voided if the team ever leaves USL. We saw a lot of that when NASL teams left to go to USL. Scheduling has already started, as you saw. USL put out their conference alignment today, which may or may not have been a coincidence. But clearly, there are forces that want to sort of constitute this new Canadian league, the Ottawa Fury are the biggest existing. Well, they're not the biggest existing team that's not a part of it, but they're the biggest existing team that they think should be a part of it that isn't, and so. Clearly, I mean, what's probably happening, unless somebody's really digging in their heels, is that this is probably more than a shot across the bow at the Fury. That you're going to have to choose sides sooner rather than later. The thoughts as to where we go from here, and again, we can talk about sort of the legalities of this, and sort of the how FIFA statutes may figure into this. A lot of folks figure that a reasonable compromise looking at this already is like, okay, you can stay one more year in USL, and then you've got to come to the Canadian League after that. And maybe that's where we're headed. But, this is a pretty aggressive move by CONCACAF at a late stage. And based on the conversations that you've had today with representatives of the Fury, they sound like they're poised to take aggressive responses in a very short amount of time if they don't hear something in the next few days, which again brings things to a head rather quickly.
Yeah, that's what I've been hearing. I was able to talk to a few people today, and they're definitely taking the stance that this is unprecedented action, which it appears by all rights to be. I don't know if, Stephen, have you been able to see or find anything of similar nature coming out of any of the federations?
You mean any action by where federations are trying to block a team? Yeah. It's interesting. So there are examples of cross-border teams. Obviously, Monaco is one example. Yeah. The Welsh clubs in the Premier League, that have gone in and out of Premier League, but are at least, the Swansea Cities and Cardiffs and et cetera. So there are examples of this that don't seem to be exceptional circumstances in the sense of, there's no possibility of a league, but it is the way that the FIFA statutes read under Article 73. You have to get authorization from the member associations, the respective confederations, if there's more than one, and FIFA. And it doesn't give any real grounds for it. And it's not clear, for example, why Ottawa would be denied, but the Major League Soccer teams would be allowed, or the Major League Soccer 2 teams would be allowed, like the Toronto second team. So it's not. So I haven't found anything that defines exceptional circumstances other than the obvious one, where there's no league in the home. In the National Association's jurisdiction, but there's a league. There's a top league and top Welsh league in Wales that you could have said Swansea has to stay there. So it's not clear how they're applying this, but it may be that individual confederations, just because of the latitude given them, have the ability to just block it unless FIFA wants to exercise power. CONCACAF may have carte blanche to do that here, at least under the FIFA rules.
Yeah. So what I was hearing and what Neal alluded to was that it looks like they are going to go after CONCACAF next week. They sent a demand letter out to CONCACAF with the deadline of this Friday, basically saying, what are your grounds? What's your legal basis for preventing us from Ottawa Fury from playing in USL next year under the exceptional circumstances prong of the FIFA statute, which Stephen rightly points out doesn't really say much of anything except for saying that you need exceptional circumstances. Assuming that Ottawa doesn't get a response, then they are going to file a petition suit with Court of Arbitration for Sport next week, and then file for a preliminary injunction. So that is, Stephen, you've probably done a little bit more work than I have on kind of the CAS end of things. So what are your thoughts on the kind of procedural next steps, assuming they do file suit and request an injunction?
Well, you can get an injunction. There is such a thing as injunctive relief within Court of Arbitration for Sport, but it is not well set up for the kind of speed of action that you might see in a U.S. court. And I don't know that they could get the kind of relief they want, certainly like within a week. It's just not, I haven't seen that kind of speed of action. It's not possible. But what they're really hoping for is some kind of relief that keeps them in USL, I assume, while the case is argued. And that's not it wouldn't be meaningless to do so, because there's still the argument that I think the Ottawa Fury want to have the option of staying in USL beyond next year. If this were just an argument about what's going to happen next year, I think it's pretty easy to settle that without even going to CAS. Probably this is, as Neal mentioned, this is probably a power play to see if Ottawa would agree to that in 2020 they're going to go to CPL when they're ready to start. That'd be fine. So this is really a more longer-term argument. Keep them in USL for next year and then go forward. In that case, I think CAS is probably better set up to do that. But I just don't know if they can act within a week or two.
I suppose the benefit is that they've got the season that doesn't start until April. We're thinking, Neal, which a little more plugged in on USL than I am. What are you expecting for the start of the season?
Yeah, I think last year it started around mid to late March. So that would, but of course, preseasons before that, and of course USL has to know. They can't get too deep into. They've started scheduling process, but it's probably not too late to change. But if you get to late January, individual teams have to know dates, not just for Ottawa isn't necessarily the ones that only have to know. The league has to know for planning purposes, and all the teams where Ottawa's visiting have to know for planning purposes. So this is something that's going to have to be figured out for 2019 sooner rather than later. And Stephen's point is well founded. It appears, and again, we're making educated guesses at this point as far as why people choose certain moves at this point. Filing a CAS claim keeps you within the auspices of what is the recommended appeal process through FIFA, unlike what the NESL did, at least as far as their antitrust claim. But it's a well-founded point that if this is a dire situation for Ottawa, they're going to have to find another route, I think, or they're going to have to capitulate, one or the other.
I don't see them capitulating.
And just to clarify on this point, so typically when you see these injunctions or these quick decisions, CAS does make them, but they make them in a different division. They make them in an ad hoc division that are set up specifically on site at the World Cup or in the Olympics. And they do it, they provide essentially that service because you need speed to know whether, the winner of the heat goes on to the next round or something like that in the Olympics. So when you're going into the sort of regular, there's no ad hoc division for this. So you're going to the regular. So you've got to get 3 arbitrators together. They're not located in Lausanne, Switzerland all the time. It's not that you couldn't get it done by end of January. So maybe, that's enough to proceed forward, but it's not as well set up as a court where they have the the judges in there and the clerks and everybody ready to go, as long as they're in session.
Yeah, and far be it for me to recommend going to the courts of law, but it almost seems like that might be, I mean, again, if this is a dire situation, that might be what they need to do. And maybe they're not going to do that, but, and again, depending on what jurisdiction matters too. If they file it in Canadian court, or they file it based on CONCACAF's location in a U.S. court, they could choose either one. And then it gets into an interesting discussion about, as Stephen sort of alluded to, the question that keeps, running around the back of my mind that I would think would have some traction, at least in some of the U.S. courts I've been a part of, is that may not be as important to a court of arbitration for sport, is dealing with Ottawa differently than other similar situated teams. You talked about the MLS teams. You talked about the USL League One teams. Why Ottawa? Why not those other teams? And I sort of threw this out on Twitter last night, and some of the responses I got were interesting, but I don't know that they were sort of legally persuasive. The responses were, well, this league is more situated to Ottawa. Well, okay. Well, why wouldn't it be legally? Why it hasn't kicked a ball yet? Why is it the same quality as the Montreal Impact, or why is it the same as Toronto 2? Well, the budgets for this league are similar to Ottawa. Well, how do we know that? I mean that's just guesswork. So again, I think there's a huge question there of why Ottawa, why not these other teams? And I mean that's the kind of question, at least to me, that if you were in a U.S. court, whether it's state or federal, or it would be federal, that would be an interesting and potentially fertile ground to explore. Now, and I'm sure that if it got in front of a CAS arbitration board, that would be a subject as well. It's just, I don't know how much weight that they put in that whole discussion as opposed to a U.S. court under U.S. law.
Well, as far as what the reasoning is, it may be one of those cases that the simple answer is the correct one, which is that the fact that the head of CONCACAF used to be the head of the CPL, or the creation of the CPL, and wanted Montreal in there. And when they refused, didn't like it, and is now, putting a heavy hand down on things to move things along. It may be as simple as that. As far as why not other teams, such as why aren't Montreal, Vancouver, and Toronto being, forced to move into the CPL. I take your point that the reasoning that the leagues are of different statures financially, first of all, we don't know that, even though we assume that's true. And second of all, I'm not sure that's an excuse or an exception that would allow them to stay. I don't know. Well, go ahead, Stephen.
That's the issue with the statute. I mean, the statute basically provides, to be clear on what the statute says, you have to get authorization from the member associations, the Confederation, and FIFA, absent extraordinary circumstances. It doesn't say that it's not permitted except under extraordinary circumstances. It says you have to get authorization. So the authorization seems to be unbound. The discretion seems to be unbounded under under FIFA rules. It's not as if you have to have a reason. In the same way that U.S. soccer could deny Barcelona from playing a game in Miami just because they don't want them there, right? They don't have to have a reason. They could say, we would be happy to have Manchester United, but we just don't want Barcelona for whatever reason. We think that's more of competition for us, or something like that. So that's, and this gets really big picture, but big picture, this is about the system FIFA has set up is very territorial, and they're giving essential, what is effectively soccer sovereignty to the member associations and the confederations, and that sovereignty is not bound by any precedent or any requirement to exercise that discretion with some kind of even-handedness or anything like that.
Yeah, and I would just to finish up, I guess, on that point. So the reason that they are not giving Vancouver, Toronto, Montreal a hard time is just because they decided not to. And I heard a rumor, this is completely rumor, but that it's possible that those three teams have agreements with the Confederation, FIFA, US Soccer, CAS to waive sanctioning or not worry about that issue for X amount of years. So basically they said that, yeah, there's no Canadian league. There doesn't appear to be one on the horizon, back in 2012 or 2013. And therefore we're just going to approve sanctioning or not waive sanctioning or not address the issue until 2026, just to pick a year out of thin air. So any of those types of things could be the result of, or be the reasoning for why they're not going after the other Canadian teams. Again, that's just something I was told just as kind of speculation, but it's probably worth digging into to see if that's actually the case. So I think we should probably just, unless you guys have anything more thoughts, this is still a pretty new case. And obviously next week, there's going to be a lot of stuff going on. If it's correct that CONCACAF has until Friday to respond and they don't, then there's going to be some fireworks next week. All right, let's move on.
The only other quick point I'll make, and this isn't really sort of, this is more of an observation than anything else, but maybe it's a jumping off point for the rest of our discussion. Sort of the backdrop of all of this, and again, it's a little bit different than some countries where leagues are sort of set up as just different divisions based on merit. There's an intersection here between sort of the territoriality and the sovereignty of FIFA and commerce. Because we're not just talking about saying, well, you got to go from this league to this league. You're talking about you can't be a franchisee of this league, and you're going to have to join, if you want to play, you're going to have to go join this other business entity, whatever their setup is and whatever their arrangement is. And then there's an interesting sort of intersection of sport and commerce there that I think I still believe gets legally dicey. Well, it gets legally dicey on a lot of different fronts, but in this case, there's another element. It's not just saying, well, you can't play here, you got to play here. In essence, they're saying, well, you can't play with this, you can't be a part of this business, you got to be a part of this business. And
it underlines the entire start of soccer, professional soccer in the 90s, really.
Right.
You talking about the 1890s?
Yeah, in the 1990s, definitely. So I guess that actually leads us right into where we can go next and talk a little bit about NASL versus US Soccer / MLS. We're actually at kind of a dead point as far as the quote unquote action is concerned. Obviously, this case was filed back in 2017. The appeal was denied as well, and it was remanded back to go forward with the trial. In spring of 2018, instead of filing a motion to dismiss, as US Soccer had led us to believe, they simply answered the suit along with MLS, who was brought in, which set the case on for trial. And at this point, we're kind of just moving through the motions with discovery. Stephen, I know you've been doing a lot of work on the discovery part of things. So we're set for a trial potentially sometime in summer 2019, I think is a fair shout if NASL gets what they want. Discovery cutoff is April 30th. So as far as where things are right now, what have you been seeing, Stephen, as far as the request for discovery, depositions, et cetera, et cetera?
Yeah, so currently it's a pretty typical discovery back and forth. So both parties are a little aggravated with each other, but that is not unusual in litigation. And the latest that happened this week is US Soccer had requested to depose Ricardo Silva, the owner of Miami FC. Apparently that had been based on an agreement between the parties that they could depose the members of each other's board of governors or board of directors. And NASL had been essentially denying them the ability to depose Silva. There was a motion to compel. Eventually, just this week, U.S. Soccer withdrew that motion after NASL finally sort of came forward, according to U.S. Soccer, with the news that Silva had resigned from the Board of Governors. It's not clear when. It's redacted materials is what we have available to us. It's not clear when that happened, but at least within the confines of their original agreement, U.S. Soccer, according to U.S. Soccer's letter that was just filed, they have been, I'm looking at it now, they've been, their directors have been, including former directors and consultants, have been deposed or agreeing to go through the deposition process. Some of NASL's Board of Governors have done so, but they're going to have to seek Silva another way as a third party. So really, you're at that stage where you're discussing. There are a lot of documents going back and forth, but the documents are all under seal primarily. So we don't really have access to this information. We just kind of get a little bit of insight into the proceedings, as they get aggravated with each other and file motions to compel.
Yeah, I know Kathy Carter's been deposed for sure, and I'm sure there's been a number of other MLS/US Soccer officials that have been deposed. Neal, what's your thought on kind of where things have gone since we interviewed Rocco? What was that, back in March or April, I think? And he had a pretty tear the house down performance, and it's not gotten any better, the relationship between the parties since, that's for sure.
No, and according to Rocco, I'm still cashing my Steve Malik checks. So, no, just to dovetail off what Steve was saying, the one thing I was going to add, and this is a little bit of rumoring that has been corroborated enough through circumstantial evidence that I feel safe saying it. Several weeks ago, I had a reliable source that told me that both Miami FC and Jacksonville Armada had sent in their notices of withdrawal from the NASL.
Is that for next year? Whatever that means, I guess.
From the LLC.
Okay, so
that's resigning, right? Yeah,
that's correct, and that may inform what happened with Ricardo Silva and the letter that Stephen referenced. And some of the circumstantial proof of that is that the very next week after someone told me that is when, and you perhaps saw this, that's when the remaining 4 team emblems disappeared from the NASL website. And that's, and that I was told that both Miami and Jacksonville, their own respective ownership groups, had issued their formal notice of withdrawal from NASL, as many other teams had already done last year. And so that may, and there's probably, it kind of got me wondering what the motivations of that may be. One may be to try to avoid immediate depositions. Another that I heard was the ongoing cost of litigation. And then another that made a lot of sense to me is that if these teams wanted any kind of flexibility on trying to find another place to play, they were finding it hard to do that while they were still involved in a lawsuit with U.S. Soccer. And so by withdrawing from the LLC, they're not backing the lawsuit anymore. They're not a party, quote unquote, as being members of the LLC. And so that's kind of where we are from that, which, informs even more that this is a Rocco show at this point. And I don't know the status of Puerto Rico. I don't know if they're still technically a member of the NASL or not. I do not know.
Yeah, and that kind of goes. Just to interrupt. That kind of goes back to when the NASL was originally saved, and they had some provisions put into the articles of formation of the NASL that any team or owners of any team could leave with essentially no penalty. Whereas in the original articles of formation, there were fairly substantial penalties depending on what time the teams left. I think it went up to about $2.5 million to exit. And so, that's kind of that would explain why they have gotten out, at least in part, is because they put in the ability to get out with very limited penalty.
Right, and there was probably some trepidation of just jumping ship, maybe incurring the wrath of the members who remained. But clearly, these two members decided that the whatever potential costs were outweighed by the benefits of leaving. So that's what I had been told. I've gotten some verification of that since then, and everything, the circumstantial and what, Steve just mentioned sort of informs that. So, so right now they're slogging away, and it appears to be a Commisso, even more so than before, it appears to be a Commisso headed effort.
And if I can jump in right there on the discovery, many of the agreements that seem to be struck with the judge limit communications to Commisso pretty explicitly in a way that suggests that Commisso is the only person who's kind of relevant right now. And so they're trying to confine, because one of the issues they probably have is a huge number of documents coming from a whole bunch of people would be kind of within the ambit of a discovery order. And so they're trying to limit to the stuff that they actually have control over currently, which is Commisso stuff.
Yeah, and obviously they were going after Commisso for any number of documents related to paying presidential candidates, U.S. Soccer Federation presidential candidates, paying for billboards to be posted outside of the AGM meetings, and then also paying or offering
Hope Solo's candidacy and cast claims.
Yeah, and the irony is that they actually seem to have gotten a lot of that stuff. Even the AC Milan did. The court, the judge has been pretty expansive in permitting, while limiting it to Commisso and limiting it to relevance. I thought he might, rule out AC Milan entirely, but it doesn't seem to have done so.
It's interesting. Obviously, the relevance is a little bit up for debate, but obviously the stuff with the paying, supporting presidential candidates, and paying off reporters or trying to write negative stories goes to credibility.
Right.
And so I'm not surprised that the judge has allowed it for that purpose. So this is going to be a Commisso show, it sounds like, until the end. It sounds like he's going to be the last man standing.
Which again begs the question: what's the end game now? I mean, I'm just throwing that out as a question. I mean, obviously there are some rulings that could have potentially disadvantageous effects on U.S. soccer, but I guess what is the end game now?
I think it seems like a principled stand to me at this point. I mean, what did they ask for there in the relief? Obviously, is declaratory judgment and a permanent injunction preventing U.S. soccer from regulating or imposing professional league standards. That's obviously been the major bee in their bonnet since 2014, I would say. Just based on my recollection of the documents that they filed, they've had a problem with a number of the requirements for sanctioning, time zones, stadium size, et cetera, some of the financial requirements, minimum net worth of owners. And so if Commisso can get a declaratory judgment on that point, then obviously that, would upend U.S. soccer quite dramatically, even if he's not going to get much money out of it.
Well, I guess the monetary damages are part of the state claim, so maybe he could jump off of that, and if he gets a favorable verdict in federal court, and then try to run up a state claim to get monetary damages.
So I would go. So I'd break it down to the monetary damages were added, right? The original complaint did not include monetary damages. It was simply for this the preliminary injunction and declaratory relief. When the monetary damages are added, it's partly a recognition that there may not be a league to save, and therefore we want money. Really hard to win that in an antitrust suit, although lucrative if they do. You get treble damages, so that'd be great. But 3 times $1 is not really very exciting, and that's NASL or its predecessors have had experience with that. The problem in winning economic damages here is that it's very hard to disentangle any economic damage that was a result of mismanagement or corruption, and the NASL probably has had evidence of both. Certainly, with the connection with the FIFA case, it's not going to do well for its damage claim. So that's the damage claim. Really hard to win. It's a battle of economic experts, and it's very fact intensive as to what was the proximate cause, essentially, of loss of money. Then the the declaratory judgment, kind of what they'd like to have is just eliminate the professional league standards, the standards that determine licensing. That ironically would help on a number of other cases, probably. If U.S. Soccer had sort of no say in any of this, then I suppose NPSL would be happy too, which is Camiso's, I guess, next project. So, it seems unlikely that any kind of a rational, pragmatic compromise going through some of the issues Miki laid out and saying, is there a better way? Could we like trade off the owner litmus test on finances for the regional requirements or something like that? I don't see that happening. It seems like he just wants to win, or at least pursue this as long as possible to embarrass as many people as possible. I don't see there being like this kind of end game we would like a more rational system.
Yeah, well, he did put out that global settlement, which U.S. Soccer declined, which was basically wanted a 10-year runway to basically get his league moving, which I didn't think was a particularly poor starting point. But then he added a number of things that were going to obviously be non-starters for U.S. Soccer, such as starting Pro Rel in 2020. Again, that sets aside whether U.S. Soccer could force MLS to do that, which is obviously highly up in the air and maybe not impossible if he were to get what he wanted in the lawsuit. But all of those things he tried to get done, U.S. Soccer denied it. And there was, some contentious back and forth, even on settlement negotiations. They couldn't seem to get along. And so, as Stephen said, I'm not sure where the room is for a settlement at this point.
No, I think this is headed towards a full round of discovery and then eventually a battle summary judgment motions. I mean, that's the next step of where this is headed. And probably, just knowing how these things go, that's probably where it'll get resolved. One way or another, probably. I don't want to handicap it, but yeah, that's where the next step is after they finish battling out the discovery process.
Yeah, I guess we should add for people who aren't attorneys. Essentially, as I said, the discovery process is scheduled to end on April 30th, meaning that all of the parties have exchanged all their information. They've interviewed everybody. They've got everything, and then they can go to the court and say, we're ready for trial. But at that point, summary judgment motions can be filed, which basically means even if we believe everything you've got, you don't have a case. And that is certainly going to happen, or the other way around, you don't have a defense. And so that would probably happen in April or May. And depending on how long it took to get a ruling on that, it still may not even get to a trial until the fall, which goes to one of NASL's other concerns is that by the time this all gets decided, and I think Stephen mentioned this, that there's not a league to be saved. And so you're just battling on the principle of the thing at that point, and money.
Yeah, and I would add that if summary judgment was granted to U.S. Soccer, I would expect NASL would appeal. Yeah. So there's still, there's more process to happen than even beyond that point before you could get to a trial.
The one thing I'll add, and again, maybe this is more intriguing to me than you guys, and again, some of this is informed by when I had Stephen on my podcast well over a year ago at this point, when he kind of opened my eyes to some of this. We've already had a few interesting aspects, even sort of in the limited preliminary injunctive process that we went through. One of them is that for a long time, we had this notion that U.S. Soccer was holding themselves out to be the lone purveyor or administrator of professional soccer in this country. It's essentially saying we can operate as a monopoly in that vein. And that's kind of an argument that they've made in the past, looking back at Champions World.
Yeah.
During the course of the arguments on this preliminary injunction, they did not make that claim this time, according to the rulings that I saw from the court. They said, or at least they reframed their argument. They said, the Stevens Act does not give us, allow us to act, doesn't give us an antitrust exemption for regulating pro soccer, which I happen to believe is correct. They didn't make that.
You've got a good shout on that.
Yeah, they didn't make that claim. What they essentially reframed it as, and I think this is an interesting and probably more correct position, is they essentially said, look, we're a trade organization. We are the American arm of FIFA via CONCACAF in the United States. And you can be a part of us and abide by our rules, or you can not be a part of us and not abide by our rules. But we're not saying, which is interesting because, you know, for a long time, there was this notion that if you tried to do a pro league outside of USSF sanctioning, that somehow they could stamp you out legally. And I don't know that that's the case anymore. Now, there's a whole lot of other problems with trying to do that, as Rocco Commisso and some of his other compatriots might be trying to do next year. But the notion that legally you can't do it, which seemed to be sort of a notion for a long time, I think has gone by the wayside. I think the position now, and again, USSF tends to cherry pick arguments from case to case that serve themselves better. I think, you know, the Crossfire case is a good example of that. But in this particular instance, they said, no, we're not saying that Stevens Act gives us an antitrust exemption vis-a-vis professional soccer regulation. Our ability to regulate that derives squarely from us being a part of a trade organization, the American arm of a trade organization, which is an interesting, and at least we've got some clarity on that issue where there wasn't that before.
You know, Neal, I would add for context for this, and again, for non-lawyers, you know, lawyers are hired, they make arguments, different lawyers come in and out of cases sometimes, and, you know, different arguments, different forum. Sometimes in the Champions World case, which is a case that Neal referenced, it's from the Northern District of Illinois. It was about a promoter who wanted to bring matches to the U.S. without paying fees to U.S. Soccer for approval for these matches, and U.S. Soccer said, "Hey, we're the ones who are in control of this." That's not well suited to a membership organization kind of argument, right? Because the promoter is a member of FIFA, but not a member of U.S. Soccer. When NASL brings arguments saying, we signed up for a league, the league had professional league standards, kind of when we signed up, we participated in and had people on the board and whatever, had process even in development of those standards to some extent, and we don't like them. That's a you know, a more suited argument to the membership organization kind of response. And so to some extent, I think they're tailoring this to this particular case.
Yeah, and obviously the Champions League case, ironically, the judge there ruled that the Ted Stevens Act didn't apply vis-a-vis U.S. Soccer regulating professional soccer, at least in the United States. But no one has seen, I think NSL has actually started to bring that argument in the antitrust case. They didn't in the preliminary injunction stage. So they might go for that at this point, but we haven't seen that yet. And I guess that's probably a good place to jump into Crossfire briefly, since that was referenced. So that case is obviously another one that has a chance to really upend soccer and youth development in the United States. We're still awaiting a ruling. I actually just wrote up a story for The Athletic on the kind of status of things. Essentially, Crossfire, which is the youth development club that trained DeAndre Yedlin for 4 years, or at least 2, I guess, based on the conflicting arguments. That was sent to the Court of Arbitration for Sport back in October. It was continued until November, and then we just got word that it's been held up again while the court considers what Tottenham had to say. Essentially what has happened is Tottenham has raised a number of arguments to say we should not have to pay solidarity fees for X, Y, and Z reasons. The first one of which was that U.S. Soccer told them, or U.S. Soccer and MLS told them they didn't have to. Second reason is that their record keeping was just entirely shoddy, and the dates that they provided were incorrect. And then third was that Crossfire is not a training organization and therefore should not be able to benefit from that because they're not putting any financial risk at stake in, say, developing a player and then he flops and doesn't sign anywhere, and they put in, you know, $20,000 worth of development, but he decided to go to medical school or something like that. So that's kind of where we are now. There's obviously a lot of background on this. I don't want to go into too much because it is kind of convoluted and dry. But basically, solidarity payments are basically when a player gets sold, a portion of the fee he's sold for when he goes overseas goes back to the youth development teams that trained them between 12 and 23. So, Neal, or I think we may have lost Neal actually.
I don't see Neal.
Yeah. So, I'll throw it to you and hope he gets back on. Stephen, what's your kind of thought on where things are based on what's been filed with the DRC and where things stand? And
well, glad to have you back, Neal.
My phone
decided
to
go outside or something. You trying to explain how it's nicer outside?
I think Camisa got a hold of my feet.
Must be. So I think that one of the issues in the case from Crossfire, one of the big problems in the case is that U.S. Soccer has asserted in a variety of contexts that this is a U.S. law issue. And so FIFA has some carve-outs. You have to follow FIFA rules, but FIFA can consider whether there are local laws that may prohibit action. That's one of the problems in being a global sports organization is that the laws differ in different jurisdictions, and what you might require in one it just may not be allowed in another for a variety of reasons. And so the problem with taking this case to FIFA Dispute Resolution Chamber is the question of whether it's legal in the U.S. And this is where there was an action brought in Houston for declaratory judgment. That's not the Crossfire people, but it's people aligned with Crossfire, similarly representing a youth club. And the case was dismissed, but for lack of jurisdiction, not on the substance. So we don't really have a resolution as to whether legally there is whether it's an antitrust restriction or some other restriction, or whether it violates collective bargaining rules, that somehow the players would be the MLS players, because that's the MLS Players Association is who was the party to the suit, whether they are in fact, do they have a legal case that would bar solidarity payments on the theory that it would add an extra cost to their fees and their ability to move, which reduces their ability to get higher salaries. So the interesting thing about this now, a decision out of the FIFA Dispute Resolution Chamber may just tee the issue up for now getting back to that question of whether it's actually permitted under U.S. law.
Yeah, and one of the interesting things I think, Neal, you raised this as we kind of transitioned, was the problem people have had with U.S. Soccer's role in this, and MLS for that matter, is their use of the so-called Frazier consent decree to bar payment of solidarity payments and training compensation, which is another issue which we won't get into here, and just essentially cherry picking the arguments to support their position, which they have a habit of doing in a number of cases. And they've kind of essentially changed their position from the mid 2000s, early 2000s, I should say, up through about 2015, where they said, yeah, we cannot do this because U.S. law doesn't allow us to now the MLS Players Association is going to sue the pants off us. And they've kind of just, transitioned their arguments up until now. We have Don Garber saying that, yeah, maybe it is a good idea if we have solidarity payments.
That's right. That's right. And I think they've it's been a moving target depending on whatever case it is and whatever the situation is. And I missed a lot of the conversation that led up to this, but I guess if we moved on to the Crossfire issue, I guess if you talked about your update, I know you posted your Athletic article today as far as Tottenham's responses and how that figures into it.
Yeah, that's it. That was just what we were getting into. So
okay,
so you can go on from there.
No, go ahead. Sorry.
Okay. Let me jump in, Miki, if I could.
Yeah, absolutely.
So there's a couple of curious aspects of this. One is people have to understand solidarity payment does not mean that the buying club is paying like an additional amount. You agree on a transfer fee, and then a portion of that transfer fee goes from the buying club directly to the developmental clubs.
Right.
So instead, Tottenham paid MLS. The transfer fee, MLS said, we're not allowed to pay. You're not allowed to pay to the developing clubs. Kind of the humorous thing is that I think Tottenham even tried to figure out whether they could pay University of Akron, which we could, if we could get the most convoluted organizations together, it would be FIFA and NCAA.
Yeah,
right? Have them just intermix their rules, and then we could probably have some fun. But so the Tottenham is the one who is opposing this petition. So in the FIFA dispute resolution chamber, you can have an opposer. It's not Crossfire who is against someone. You can have groups who are saying we oppose this interpretation, and it wasn't MLS, it wasn't U.S. Soccer, it was Tottenham. Now Tottenham kind of already. The question is whether they're going to have to pay more in this scenario, or whether they already paid what they're supposed to, or they think they got a bargain. Essentially, I don't know. But in any event, Tottenham's the one objecting. So that's one thing that's interesting. Second point I wanted to make is. Go back to Don Garber. So Garber is now, hey, this is a good idea, but some people have noticed that he said it's a good idea for MLS academies, development academies. Now, there's a conspiracy theory, that he really just wants this for MLS. But let me, I give him credit for that because that's who's hired him. So he's not really advocating for Crossfire here. If it's a good thing for the people who pay his salary, then that's what he's going to advocate for. But there is a question in the rules, in FIFA rules, as to whether there's a distinction between the MLS academies and the development academies and youth clubs. A lot of people think this is opening the door to youth clubs generally. It's not clear whether that's the case, and that's because of the definition of club in FIFA statutes. The FIFA rules on transfer players define a club as a member of an association that is a member association of FIFA. So you're a member of U.S. Soccer, or a member of a league recognized by a member association. Well, the only league recognized by U.S. Soccer directly is the U.S. Soccer Development Academy.
Yeah, USSDA.
And so Crossfire fits, all the clubs that will be involved fit, but it's not clear whether the sort of local youth club would be covered here, which is why I like to put pump the brakes a little bit on whether this really solves everything in U.S. youth soccer in terms of pay to play. Because if they could limit it, even if they allowed solidarity payments, they could limit it to those development academy clubs.
Yeah, and going back a little bit to what Tottenham's arguing, which is essentially, like I said, that the records are shoddy. They already paid MLS, and that Crossfire isn't a training academy or training organization.
Training club.
Thank you. Going back to the issue of them already paying, Stephen's correct. Basically, the buying club basically carves out a portion of the overall fee and ships that over to the development academy, which in this case would have been Crossfire. The problem for them in this particular case is that they argued on the one hand that training compensation wasn't necessary based on what MLS told them, but they were also sending out letters basically saying we already paid the entire training or the entire transfer fee to MLS, inclusive of any solidarity payment. So they're basically trying to have it both ways. And the initial letters that they sent when Crossfire first approached them were basically like, oh, yes, we do believe you're entitled to solidarity payments. Please confirm the Yedlin's player passport and provide us with a bank account number so we can wire the money. And then, a month later, after they talked to MLS, and MLS obviously was trying to get their hands on the entire thing, their story changed. So, some of their reasoning is not going to stand up to scrutiny just based on the facts. There are letters which flatly contradict what they're saying. But their overall argument or their the broader argument on the issues that U.S. Soccer were having with record keeping is something that is probably much more fertile as a defense of sorts, saying basically U.S. Soccer was just so manifestly unorganized and incompetent that how can we figure out exactly how much money's paid because the passports were just completely incomplete.
Yeah, you could imagine a scenario where Crossfire wins the principle that is you're supposed to have solidarity payments, but not the case because you don't have good enough evidence in this case for what you're claiming. And then U.S. Soccer has to revamp the passport system to be better record keepers. Yeah,
I think they already have. I have Yedlin's passport, his incorrect one, and you can see the problem there. It basically said Yedlin at Crossfire, and then it just has the years 2008/2010. There's obviously a large difference in how much time that could include based on the months that are included in that. So you can understand why Tottenham's kind of jumping up and down saying, hey, how are we supposed to calculate accurately solidarity payments when they just give us a couple of years and you're asking us to rely on what Crossfire is saying, who has all the incentive of the world to fudge things a little bit to get a little extra coin, which, again, is casting aspersions on Crossfire, which are probably unfair, but especially since this is U.S. Soccer's fault for not keeping the records.
And just to be clear, solidarity payments increase the longer you are at a club. So that's why this matters a lot.
And you guys may have already talked about this sort of big picture, but the big picture is it appears that we may be hurtling towards a situation where you're going to have solidarity payments and training compensation in the United States, which, Don Garber coming out and saying it might not be such a bad idea is probably the best sign that he thinks that's the way it's going to go, along with the rumor that I saw on social media today that perhaps he's thinking of requiring MLS academies to institute U19 levels, which to me rung sort of alongside that possibility. Along with the fact that if Tottenham's gotten to the stage where the weedy arguments are, how much do we have to pay in this particular case?
Right.
We're past the point, or at least they believe we're past the point where not being able to pay at all is an argument. And I'm glad to hear what you said regarding the arguments that Tottenham was make. I do think some of the shoddy record keeping may be more detrimental to Crossfire than the argument that, well, we already paid it to MLS. That's not going to, that wouldn't fly in any court in any respect in the country, in and out of sport. I already paid it to this other guy. You go get it from him. That doesn't work at all. Ever.
Well, and just to go back to the record keeping thing, not in U.S. Soccer's defense, but just to explain this, all the member associations are required to keep this data, but U.S. Soccer didn't have solidarity payments and training compensation. So for years, they're being asked to keep data that was in some sense just archival data. I mean, so we could go back and look for the biographies on their player websites or something like that, because there really wasn't anything to do with it. So, so it makes sense that they were not very good at that or didn't devote a lot of resources to be very careful. You can bet in places where they are counting on making money on solidarity payments that they're very careful.
Yeah, they probably got time punch cards for those guys. And on that point, obviously U.S. Soccer wasn't really in the development business before 2003, 2004, if that.
Yeah, exactly.
And so they obviously weren't keeping those records. Again, that's not necessarily a defense, but I suppose it does explain why they didn't have those records and weren't keeping them. But it may come back to bite them as a result.
And just one quick question, I guess, for both of you. I guess I don't see any way under procedure or circumstance or even fairness where Crossfire would have recourse against. Now, again, you referenced a nuclear option in your Athletic article, but I mean, would Crossfire have any recourse against U.S. Soccer if their record keeping diminishes their potential recovery here?
Talking to Lance on that score, it sounds like if that were to happen, if the worst case scenario were to happen, where FIFA, the DRC comes back and says this is just impossible to calculate, and this was such manifest incompetence that we're not giving you anything. Or as Stephen said, we agree that solidarity payments should be imposed, but you're not winning this particular award. His next thought was that a class action suit would be brought for any team or development academy that was affected by this ruling based on U.S. Soccer's incompetence. Obviously, he also mentioned that they could go to and petition based on the Ted Stevens Act to have the U.S. Soccer charter revoked based on this as well. And then also go to FIFA or Court of Arbitration for Sport for sanctioning. So those were all things that he told me were on the table if something like that were to happen. Whether he would have the desire to go through that process, I think he certainly would. I have not obviously researched the viability of those types of actions, so I'm not going to go and say this is a slam dunk case and we're going to have a new federation in 6 months.
And one thing I'd add is the other aspect of U.S. soccer, which is different than almost all other soccer jurisdictions, certainly non-federal systems, is that we have all these regional, state-based soccer authorities. Yeah. So, it could be you're registering with, especially before DA, you're registering with the Washington, whatever it's called, Youth Soccer Association. And, U.S., so it's really a problem of, an intermediary is not giving it to U.S. Soccer or something like that. And so there's some questions here as to who would be the proper party who, didn't report this. Because I'm not sure that, before Development Academy, I'm not sure who's reporting to U.S. Soccer, the players that are participating in, the Washington State.
Yeah. All right. Well, I think we can, unless you guys have anything else, I think we can move on to the last, most recent U.S. Soccer lawsuit, which is the U.S. Soccer Foundation has filed a suit against U.S. Soccer. For those who don't know, U.S. Soccer Foundation is a charitable organization mainly devoted to providing opportunities and access to low-income kids to play soccer and participate in those types of activities. They've been around since the mid-90s. They were started with a grant of sorts, you can correct me if I'm wrong, from the proceeds from the World Cup. The issue is that U.S. Soccer, at some point in the last couple of months, I think in August and November, essentially said that, approached the U.S. Soccer Foundation, said, we would like to use your name and Mark's logo for whatever purposes in the future, which they have not outlined at this point. And therefore, U.S. Soccer Foundation, you need to change your name, you need to change your logo, hand those over to us, and we'll take those in. Thank you very much. U.S. Soccer Foundation was obviously upset about that, given the work they had put in to build up that brand, taking in donations, marketing, et cetera, and just establishing an identity as a charitable organization. And therefore, they have filed a suit in D.C. District Court. Is that where it's at?
Yeah.
Okay.
D.C.
Yeah, in D.C., basically asking for an injunction, declaratory judgment. I don't think they're asking for damages that I saw. And then they're asking for some changes to the trademark. Stephen, you were covering this as well. So I think that's right. My summary is correct, essentially, but I'm sure you've got some stuff to add.
No, that's right. One interesting note about U.S. Soccer Foundation is the formal legal name is the U.S. Soccer Federation Foundation. Which just gives you an indication of how closely linked they once were. They were seeded with money from the 1994 World Cup, but they were formed as a separate organization. They have what you might call an interlocking board of directors. So there are multiple past presidents of U.S. Soccer Federation who are on the board of the U.S. Soccer Foundation or U.S. Soccer Federation Foundation. So pretty closely connected. U.S. Soccer Federation has always filed for the original trademarks. So they own the trademarks. The question in the case is, and the case repeats it many times, the complaint repeats it many times, is that U.S. Soccer Foundation has been able to use those trademarks without oversight or control of U.S. Soccer Federation for years. That links into a legal doctrine called abandonment. So the question is, if you abandon a trademark for more than 3 years, then your claims to come back and take it are limited. And in this case, there's an exception to that. If an affiliate or a related organization uses your marks, then you can keep ownership of it. So there's probably going to be some arguments about how closely linked they are. One curious point in that particular argument is that U.S. Soccer Foundation changed its logo recently in 2017, just updated. It's a similar logo, but sort of a sharper font or whatever you want to call it. And they had U.S. Soccer Federation do it, right? So U.S. Soccer, they went back to U.S. Soccer Federation, we want a new logo, and they filed for the trademark. And it's, again, filed in the name of U.S. Soccer Federation. So it suggests that U.S. Soccer Federation is heavily involved in this. Legally, I think there's probably an argument that U.S. Soccer Federation still owns these, still has some control, probably gets to keep them. The bigger question is what is U.S. Soccer Federation planning on doing with this? They did start a few years, was it a few years ago or maybe last year? They started to try to actively collect money for this player development window. It looks to me like World Cup 26, they're thinking there's going to be a lot of charitable opportunities for us that can go beyond the mission of U.S. Soccer Foundation. We want to do it. We don't want confusion.
Neal, what are you thinking?
I'm more questions than answers. Going back to the inception of the foundation, which, we often see for-profit corporations that establish, charitable 501c3 nonprofits as a place to sort of funnel their money for tax purposes. But in this case, the U.S. Soccer Federation was and is a 501c3, establishing another 501c3 as a charitable foundation. So, from the inception of this, which, according to some of the history, Alan Rothenberg, when he's president of the U.S. Soccer, was the one who helped set this up. So, I mean, there's close ties between the two entities. I guess just as maybe it's not an academic question of why this was set up to start with. Why didn't they just house their charitable arm within the existing nonprofit? I don't know. But that was just an interesting question that I still can't wrap my head around. One other aspect to sort of the legal claim, and I think there's some of the more ancillary claims that the foundation is making have to do with unclean hands and unjust enrichment, which the former is difficult to prove, but there is a persuasive argument now, and I agree with Stephen that I think on balance, the legalities, especially when it comes to courts interceding and patent claims or trademark claims, that on balance, the U.S. Soccer Federation probably has the slightly better argument. But there is not just an equitable argument, but maybe a persuasive legal argument when it comes to unjust enrichment or something of that ilk. Of the Federation, I mean, this has been a separate entity for 20-some years, which has built up a good reputation and goodwill and value, apparently, that now U.S. Soccer Federation just wants to kind of swoop in and reclaim. And I think there is, when you're talking about a separate legal entity, there is an interesting legal question of the extent to which the Federation could just allow this organization to operate under this trademark and this name and do the good work for 20-some years and then say, oh, we want that now. And something in the back of my legal mind just says that that's a problem. And I
think so too.
I'm curious what the legal argument would be there, or the most persuasive legal argument would be.
Yeah, and obviously the repercussions of this for the foundation. I talked to the president, and he was obviously very upset about this entire thing. Reiterated that this is quote unquote a divorce from U.S. Soccer and the foundation. And I think I asked him what would be the consequence if they were required to go out and basically start from scratch. And he didn't say it in so many words, but the implication was there that it basically ceased to exist. And because of the difficulty in starting from scratch. Again, maybe that was for my benefit as someone who was asking the questions to report out and basically say U.S. Soccer trying to destroy the foundation. But there is something to be said, as you said, 20 years of work and goodwill, and to see someone else come in and swoop it up for some as yet undetermined purpose. We can speculate as to what they'd want to do with that stuff. It seems pretty silly to think that they would just mothball it after going through all this effort to reclaim it. But there is a serious consequence to this effort from U.S. Soccer, which makes me wonder why they're going through that if it's not about money and or marketing.
Well, and again, I don't know what the agreement is, and maybe you guys can speak more to this. I don't know what the agreement is between the two entities, but I mean, the funding for the foundation comes from the U.S. Soccer Federation and its revenues. Why couldn't they just starve them to death if they wanted to and just keep it?
Well, I don't think that's the case now. I think they originally seeded that way, but not even. It's not the U.S. Soccer Federation paid money over to U.S. Soccer Foundation. No. It's more that the organizing committee of the '94 World Cup, which is a separate entity from U.S. Soccer, I think had surplus funds and sent it and seeded the foundation that way. That's my understanding.
Yeah. I think that's right. They essentially seeded the money and said, "Go off and go do good works."
Right.
And they haven't met since, except for to the extent that board members are intertwined between the U.S. Soccer Federation board and the U.S. Soccer Foundation board. Carlos Cordero's on both boards. Right. Sunil Gulati's on both boards. Again, which raises questions about what their role was in this, which is another question I asked, which I didn't get an answer to. But that's
Rothenberg's still on the board.
Yeah,
Rothenberg's on the foundation board.
Okay. So yeah,
but there was some discussion that this may be a move that's being made in advance to possible revenues and merchandise from the 2026 World Cup. But again, that's what I mean. There's no obligation for the foundation, for the federation to involve the foundation in those revenues to start with. So I guess again that goes back to what is this all about?
Yeah, Neal, my guess is so. As to the origins, I had no involvement and I don't have any inside information, but there is a difference between being the private foundation and an operating entity. And so there, from a tax perspective, there may have been advantages to keeping the money separate so that you can get public charity status versus if U.S. Soccer's revenues are linked in, then they don't look like most of their money is not coming from raising charitable funds, a very small amount. So bringing it back in, they may expect, we're not worrying about that tax issue anymore, or that, what's called unrelated business income or anything like that. It may simply be U.S. Soccer wants to start raising money and they want control over that money and they want to do good things, but they don't want these guys to run what they want to do with it, which might be player development or might be things that are perfectly great. Like we would like to seed youth soccer in an elite way, development academies. We want to give scholarships, whereas U.S. Soccer Foundation wants to give grassroots.
Yeah, right.
So different views. So it may just be two groups arguing over what is the best use of charitable funds. And you could see how U.S. Soccer would say, if there's this group out there that's calling themselves U.S. Soccer Foundation, it's going to get confused if we're out there trying to raise money for U.S. Soccer Federation. You could see it. I don't know that it's worth the public relations disaster this is, but that's might be what they're going for.
Right.
Okay, so I think that's good on that, because obviously this is a new case that is we haven't gotten response from U.S. Soccer, and there's still some time before this thing kind of fleshes out. So unless you guys want to add anything else, we can kind of finish up talking a little bit about Save the Crew, and they have been saved essentially at this point. It looks, based on what I'm hearing, that they should have this wrapped up in about 2 weeks. There was a memorandum of understanding that was released by the city of Columbus and the county, basically saying, here are the agreements we're making with MLS and the owners there. They're pitching in like $150 million or just under that. for either construction of the stadium or construction of infrastructure, things like that. And then MLS, the owners, are putting in the rest. So that's kind of the end of the story. But obviously, the part of the reason that they were able to be saved is because this lawsuit was filed back in March, which used the never used before Modell law, which was passed in the wake of the Cleveland Browns moving to Baltimore. So, back in March, this was filed. The parties argued basically all throughout the summer. At some point around probably September, after the motion to dismiss was filed by MLS and argued to get the case essentially tossed out, they were able to come to an agreement, at least a preliminary one, and it looks like the team is close to being saved. But I kind of want to just get your guys' thoughts just on kind of the law itself, the application from the city when they filed the suit, and whether you thought this was something that would actually work, because it appears to, if not outright worked, at least provided a pathway for them to come to an agreement.
Well, I can just jump in and say it certainly provided leverage. A law, you don't always have to have a law be upheld all the way to the Supreme Court, for something to work legally. Sometimes filing a lawsuit gets people to the table, and also generates a movement. This certainly seemed to attract a lot of attention. Maybe saved the crew as a movement would not have started without a lawsuit. So it worked in providing some leverage, some PR, a rallying cry. It got politicians interested who probably were necessary to help get ultimately the funding for the new downtown stadium. So, those things are all positive aspects of the lawsuit. Whether the Modell law has been sort of upheld as being a viable source of authority that other states should adopt, not clear. Right, it's not clear yet. That we just didn't get far enough in the case.
Yeah, it's been stayed obviously at this point after the motion to dismiss was denied. And one of the interesting things from the law, Stephen, I think you also either tweeted or wrote about, was there were a number of the elements of the law that were the arguments from MLS and pre-court were fairly summarily dismissed. One argument that they won on, and maybe the key argument, is whether they had to provide an opportunity to purchase a team and what that meant. The court basically found that opportunity to buy means exactly what it says. It means you make an offer, I'll consider it, and we'll kind of go from there. And we never got the end of that sentence, but it provided clarification as to what exactly the law required pre-court and MLS to do.
Yeah, the interesting thing about the motion to dismiss opinion is that this issue came up not on the substance of the claim. So it was an opportunity to purchase provided. Right? That would be the substantive claim. This was on whether it was the statute's opportunity to purchase language was so vague that it would be void for vagueness under the Constitution. So procedurally, that's just not the place where you have this. Yet the judge cast doubt at the option or right of the city or state to buy if they offer a reasonable price. Right? They had been making this argument that if we provide a reasonable buyer, a buyer with a reasonable fair market value purchase offer, that the crew have to accept, and they can't just decide, you know what, I want to move, right? Which ironically is what Modell, Art Modell, wanted to be able to keep the team so he could, pass along to his kids, and so no price was a good price for him. So ironic, so you might say legislative history, that's what they meant, but the court could have just said, I don't have to deal with this. It's not vague, but he said, I have doubts about whether you could stretch it that far to be an option. I think it's either way, though, I don't have to go that far. So the fact that he said I have doubts, is probably not an indication he was leaning towards a very hard ruling on that point if it had come to it. So I suppose in the future, that's the sort of to be determined if this issue ever comes up for an Ohio sports team, they would probably pick off on that point, cite his doubt, and hope that that convinces another judge.
I think on that point, yeah, as you said, that's a substantive or factual ruling whether they provided an opportunity to buy. What we don't know, obviously, following that is whether the opportunity has to be reasonable or not. Because that again is not in the statute. It doesn't say reasonable opportunity to buy, it just says opportunity. Now, I tend to think a court would say if some buyers came in with a $500 million offer and pre-court demanded $3 billion. A court's probably going to find that not to be an opportunity to buy. But we don't know that because he didn't get that far. And obviously the parties have settled now, so it doesn't look like we're going to get that far. So I guess I did want to ask, because Neal, you've got a couple of teams out in Carolina who are somewhat affected by this, in that there was an expansion or is an expansion race going on. And because the Crew appear to have been saved and Austin looks to have still gotten a team, that the previous 27 and 28 expansion slots appear to be full. And I wonder if they've talked anything about how that impacts things out in Carolina out there based on that.
I think for just a moment. Repeat what you were saying one more time. Sorry.
That's all right. We see that's a fine-looking picture of you.
Yes. That must have been from some time ago, or next of kin, I should say. My question was, because it looks like the Crew have been saved and Austin is still going to get a team. Right. A couple of the expansion spots appear to have gone away. They've been filled, and I'm curious if there's been any reaction to the fact that there appear to be no open immediate expansion slots out in Carolina, or are they taking Garber's news that they may be expanding and being like, okay, well, fine.
I think that the belief behind the scenes by those who matter, namely Steve Malik, has been that it was never going to be 28, that there was a delay in the initial announcing process, and that even if they got to 28, that if another viable alternative came up, that MLS would not turn it down. And so I think the operating assumption, and maybe more than an assumption, has been that all along. I mean, Don Garber was here doing site tours with Steve Malik as recently as early in October, and I know that for a fact. So I think things are going along, and the notion that there was ever going to be a pause at 28 is probably fanciful. I think Raleigh's, their issues as far as getting an MLS expansion bid are the same as they've always been, which is finding a viable stadium plan and a viable location. And if they ever accomplish that, I think things may turn, although there's some other factors as well. But I don't think that anyone ever put much stock in the notion that this was going to stop at 28. And I think Garber's crack in the door acknowledged what a lot of people always thought. One other issue about the Crew thing, and again, this is probably going to shed light on my ignorance more than anything else, because you guys have been more plugged into this beat than me. A long time ago, somebody, in regards to the Modell law, somebody sort of posited the argument to me that, and I wonder whether this argument was ever made and whether it had any traction or it was just summarily dismissed for one reason or another. The argument is, and it gets to sort of the makeup of MLS's single entity, that unlike a lot of other leagues where you have separate organizations that quote unquote would move, that MLS being organized the way it is, that essentially what would have happened or could have happened is that the Crew would not move, that they would essentially be a branch office that was closed and another branch office would be opened in Austin. And that goes to the single entity aspect of a construct of MLS. And, that sounded like, especially in light of, the way that the MLS got around in the Frazier ruling years ago, it was an argument that sort of at least made some sense to me. And I'm wondering whether that was ever a factor in the Crew saga.
Not really, because I just don't think we got that far. in the argument.
Okay.
Because the motion to dismiss took precedence. There were some shots at MLS's single entity culture or construct in the ruling. But again, I think at this point, because the case has been stayed, and we're within 2 weeks of probably having an announcement that the team is staying, that it's a bit of a moot point right now. So,
although I would add that the way it has resolved, which is sort of not transparent to the average person, is definitely because it's single entity. They were, it seems like, and Miki, correct me if I've got this wrong, it seems like they sold to Haslam and Edwards an expansion slot in Columbus. They allowed Precourt to move, perhaps according to his right in his investor operating agreement.
Yeah.
But because the league retains the right to allocate players however they want, that's still one of their rights, and they own all the contracts. The players all stay with this expansion team, and they're not under the expansion draft or anything like that. So that's very much a single entity solution. And I can tell you, as someone who teaches tax law in addition to sports law, that there's real tax advantages to that, because Precourt didn't sell anything, and therefore he moves without having to, sell his franchise and pay capital gains taxes on that. So, so that was single entity driven for sure.
Yeah, I think, to kind of finish up, I think we just don't know the answer to that at the moment, because the sale is not official. Not that I think MLS will provide that information overtly, but Columbus being the expansion team, with Precourt going off to Austin and taking a hiatus of sorts, does kind of line up with the branch office theory, basically saying they're going to send Precourt down to floor 7. And allow him to do some remodeling, and then they'll be able to open it up in a couple of years. I mean, it seems overly convoluted, but in a single entity structure, if that's what they've got to do to maintain that structure, that's what they're going to do. So, it's overly convoluted, but it sounds like we'll have at least an answer on the sale in the next 2 weeks, and then we can start trying to dig around to figure out exactly how they facilitated this. So. Okay, so I think that is good for us. I think this is a great little hour and a half of chatting. It sounded like I think we got a lot of information out there, so I hope that people out there who read or listen or watch or listen to this enjoy it. I'll get this published out here pretty soon, and then I'll try to also convert it to a SoundCloud file so that people who don't want to look at our faces can at least listen to our voices. So I want to thank Professor Stephen Bank and Neal Morris. Thanks a lot, guys, for doing this for me. This is fantastic. I had a great time.
Enjoyed it. Thank you.
Thanks, Miki. Had fun.
All right. Thanks a lot. And I will talk to everybody later. You can find Professor Stephen Bank on Twitter at Prof Bank, right? And Neal Morris, I am Neal. Is that right?
By Neal Morris.
I know. By Neal Morris. Their Twitter handles, and you can find me at Turner ESQ. So thanks a lot, and we'll talk to you soon. Bye.